Vercammen, and I'm an attorney in Edison, New Jersey, and I thank the Piscataway Library for inviting me to talk, and for the people who are on Facebook Live watching, listening, and in the future. So typically people ask me, Ken, why do I need a will, or what happens if there's no will? Well, if there's no will, typically you're creating problems, more aggravation for your family. People say, okay, yeah, does everything go to the spouse? Well, if it's a first marriage, yes, but if it's second marriage, no. And if you want to guarantee more aggravation and fights amongst your family, don't do any planning. It's like not changing the oil in your car and saying, I'll get around to it. So, if there's no will and there's kids, the procedure becomes much more complicated. Every child has to sign a renunciation saying, we all agree upon one person to be the administrator, and sign in front of a notary, then pay a fee to file those renunciations. Well, sometimes you get, sometimes you get the troublemaker, brother or sister says, no, I'm not signing that, I want to do it. Well, then a complaint or a show cause has to be filed in the Superior Court. Most people want the estate to pass as easy as possible, so that's why you have a will. Number two, if there's no will, the administrator, because it's administrator, if there's no will, rather than executor, has to pay money for a bond that costs about $1,000. Three, if someone has minor kids, no one plans on dying, but when you have minor kids, if there's no will, an old white guy at the courthouse determines who gets custody of your kids, and a lot of people say, no best person to raise your kid, but who don't you want to raise your kids? But most importantly, when the loved ones are grieving, you shouldn't give them one more thing to stress about. So think about who do you want to get your assets, who you don't want to get your assets, also beware of online documents not prepared by an attorney, because the problem with using things online is that people typically don't sign them correctly or do them correctly, and there's a story of someone that says, I can do my own electrical work by watching this YouTube video or reading a book. And no. If you do your electrical work wrong or your plumbing work wrong, your house burns down and you have sewage going from the top floor to the bottom floor. Also, the cheap or free things online don't have a clause that says no bond required. And there's no reason why people should not do planning, because law offices have made it simpler. The old days was take a half day off of work, then sit down with the attorney and you take a pen and write stuff on it. That was the dumb way. The easier way is the attorney will email out a questionnaire. Someone types up the information, emails it back, and the attorney calls. We periodically get some of the seniors that says, I'm not good with the internet. I goes, well, you know who is good with the internet? Your kids or your grandkids. And geez, if they don't want to help you when you're trying to give them money, write them out. I said to the group, I go, wait, your grandkids won't help you getting money. I'd say, okay, good, tell them they're not getting anything. Anyway, so logistically, it's easier, we get the form, we tell the people how much, people can pay by credit card online, and then we email the documents to people, and then they have the option of either signing in our office on a Wednesday or coming in, or going and signing in front of a notary. Easier. So what's the things you've got to provide to the attorney? Well, your name, who's going to be executor one, who's going to be executor two. Let's say you don't want to have a joint executors because it creates much more work. That means two people have to do everything, and sometimes you get people who don't agree. We do have some people, I mentioned that sometimes they're not good with computers or they're older. Hey, listen, the kids fill it out, that's fine, but I have to be able to call that senior up and speak to them. Let's see, and I prefer to speak to them when the kid is not in the room telling them what to say. Today someone called, Dad wants a will, but he wants a clause saying that someone gets $20,000 less or something like that, and I go, we need a phone number for him. Well, he's an assisted living, he doesn't have a phone, then we're not going to do it. Sorry, but this is another reason why you do your stuff now. We get calls, it's like every other Friday. I need to get a will or power of attorney for mom, dad, or Uncle Joe. No, you can't get anything. They have to affirmatively say they want to do that. So again, it's kind of the call to action. New Jersey, believe it or not, did away with some taxes. There's no more state tax in New Jersey. The inheritance tax was eliminated for spouse, children, grandchildren, stepchildren. So we just ask people, okay, where's your real estate and a ballpark amount of your other assets? But remember, a will can only transfer assets that are owned by you and don't have a direct beneficiary. Certain assets transfer by title. So what's an asset that transfers by title? The real estate. Real estate owned by a husband and wife. One of them dies, automatically is owned by the survivor. We get the widow's cost. I need a new deed because it has my husband's name on it. I go, man, there's no reason why you need to spend $700, $800 on having a new deed that you own it. Trust me, it is yours. See, now sometimes in the States, the property is left to, it's better to say my assets are divided amongst my kids rather than saying I want my house to go to my 3 kids. Because if the will says the house goes to my 3 kids, unless it's the kind of like vacation house you want to keep in the family for a while, that means that all 3 kids got to sign the listing agreement, all 3 kids got to sign the deed and every other document. So it's better just to say, listen, everything's going directly to my kids. Other assets pass direct by under contract. So if there's a bank account payable upon death, joint tenants, automatically goes to survivor. The will can't change that. Other things, IRA, 401k, life insurance. A will cannot change that. So it's a good idea sometimes, unless you're 1,000% sure. The idea is planning is to make it easier for your executive. Go get a printout, get it in writing, put it in your will file, and say, okay, these are the ones that are direct beneficiary. Then you're going to type up for the attorney who's going to be your beneficiaries, and it's your right to determine who gets what. We had a nice lady. She goes, "Do I have to leave everything equally to my kids?" No, ma'am. What's your concern? Well, one of my kids lives on the West Coast. We don't see much. Okay, ma'am. Let me ask you a couple questions. Did he call you a single card for your birthday, Mother's Day, or Christmas? She goes, no. Why would you leave this bum anything? You haven't heard from this bum. This bum hasn't said, hi, Mom. Why would you leave him anything? On the other hand, someone called us, he was written out of the will, and wanted to contest the will, and I said, okay. When was the will done? 4 years ago. How many times have you seen your dad in the past 4 years? None. We had a falling out. And he goes, okay, well, what are your grounds to contest it other than, you didn't get a piece of the pie? I don't know. I would not take that case because the judge would say that to me. Mr. Vercammen, what are your grounds for contesting the will? The kid didn't visit dad for 4 years. Didn't send him a card, didn't say I love you or whatever. Wasn't there when he was sick and dying. So it's someone's right to determine. More and more though, people are not leaving their money to their kids. Some people say, listen, my kids already have their own house and they're okay. I'd rather leave it to my grandkids to pay for college, for grad school, etc. And some people don't have it in equal shares because they might say, okay, this kid is married to Dr. Rosenberg, the plastic surgeon. They're very well off. I'd rather leave more to my younger daughter because, her husband left and he was a bum and she needs it more than the other. Some people have what's called specific bequests. They leave, an amount of money to a child, a grandchild, sometimes money to a church, a charity. Some people leave, specific items, specific because of an item. Ladies sometimes leave their jewelry to a granddaughter. Some people will say, fellows that are sportsmen, they leave their firearms to someone that has that goes hunting in Pennsylvania. Sometimes people have. I usually say, be specific. the reverse specific bequest. I leave nothing to this person or this person. We don't leave a dollar because then you got to follow getting the check cash. Get it, nothing to that person, period. Be specific, and also make sure that the will is clear that if one of the people passes away, who gets their share. Don't have anything dangling. We also have in the wills what's called a testamentary trust for people under 21 or under 30, because 19-year-olds don't do smart things with money. They go to Seaside and spend beer, because that's what I did. Instead, for sometimes, when people have minor children, they get some when they're 22, some when they're 25, some when they're 30, but if someone's writing a testamentary trust to say, listen, one of my kids has issues. They could have financial issues, substance abuse issues, mental issues, and they have one of the other kids be the guardian of the money to make sure that the person's rent is paid, car insurance is paid, rather than just giving the money outright. If you give an alcoholic $1,000, he'll buy $100 worth of booze and then waste the rest of it. The law used to be, before it's changed, that the person signs or two witnesses sign, but then you had to go and locate one of the witnesses, which was a problem, because it was done in the law office and the witnesses are gone, the lawyer could have retired. I'm not retiring for another 25 years as long as I can sit down with nice people. But anyway, there's a new, under the revised law, it's called a self-proving will. The person signs, the two witnesses sign, the attorney notary signs, everyone else signs again with certain language, so that the family does not have to locate the witnesses. But these cheap things you find online don't have that. It is important to let the attorney know if anyone is receiving SSI or STD, or reasons why they shouldn't receive money. If your kid's receiving Social Security disability, they get a lump of money. Social Security can say, okay, we're not giving them any money anymore. Logistically, the will is signed by the person, and then they keep the original. It's important that you let Executor 1, Executor 2 know where the originals are. Don't keep it in a safe deposit box, because remember during COVID the banks were closed. You couldn't get to it. Someone needs on an emergent basis on a weekend a power of attorney or living will. If someone's in a hospital, well, you're not getting into that bank on a Saturday afternoon or Sunday afternoon or a Friday night. So that's what. People sometimes ask me, about trust. And my mother-in-law used to call me every other year. I want to come in and get a trust, living trust. I would say, were you watching Susie Orman? She would say yes. I goes, Susie Orman is right. If you live in New York, California, Florida, where the probate process costs $15,000. But having a revocable trust means that you're doing the document, but your assets are not going to be owned by you anymore. It's owned by the trust, similar to a corporation. So again, sometimes someone in New Jersey says, I want to set up a trust or LLC, or to own my assets to protect me from liability. Okay, well, I usually say in that instance, it goes, okay. Now you understand that even if it's owned by a trust or LLC, if you're the one who's negligent, you can still be responsible. Number two, if it's a revocable trust, since you control it, you're still kind of on the hook. Some people set up trusts that they want to shield their assets from nursing home expenses, Medicaid. Those are called irrevocable trusts. And an irrevocable trust, what that does is, as long as 5 years go by and you don't own you haven't owned those assets for 5 years, it's protected from Medicaid by planning on spending $5-6 grand to have it done. Some people have what we call legal insurance, legal plans where it pays for the cost of doing a will. So some of the common ones in New Jersey is MetLife Legal. It used to be Hyatt Legal, IRA Legal Plan, Legal Ease. Some of the retired auto workers, the UAW had a legal plan. So having wills done, doesn't cost thousands of dollars. Usually, you're paying unless it's something that requires, substantial specifics such as special needs trusts or things like that. The next thing we're going to talk about is the power of attorney. Now, what a power of attorney does is you're giving the power to someone to be able to do what you can do legally. I'd say a power of attorney is effective either right away or only upon disability. What I typically recommend is that the power of attorney be effective right away, because why have to go through the hump and hurdles to prove someone's disabled? Now, interestingly, some of the banks and institutions were giving people a hard time on the power of attorney. Oh, it wasn't done in our form. So the legislature came up with a law to say if it makes reference to the New Jersey statute, then the bank has to honor it. But the power of attorney has to say in writing to conduct banking transactions as set forth in Section 2 of PL 1991 C9546:2B-11, and I'm pretty sure that those cheap things online don't have. A will does not need to be updated, even if your beneficiaries and your executors remain the same, even if they move far away. I do recommend a new power of attorney be signed every 5 years, or if anyone in the documents address is changed or their name is changed. So an example, someone has a power of attorney, one of their agent is their daughter gets married, has a new name and a new address. The problem is the daughter brings, is trying to help out mom and brings it to the bank, and the bank goes, you show me ID, this is someone else. Oh, well, that's my maiden name, that's where I used to live. The bank is, I don't know about that. Okay, the last document we're going to talk about is the living will and durable power of attorney, and that's the one where you're giving instructions to hospitals and doctors saying, if you're in a coma, irreversible condition. Most people nowadays say, listen, if there's no hope for me for talking again or speaking, I don't want to have feeding tubes, respirators, things like that. It's not where someone has a heart attack, where they're, buying vegetables, that they're not going to do anything. They'll do their best. But on the other hand, you don't want to put the burden on the family to have to decide. Because I remember a doctor one time saying, okay, should we remove life support today? Because the person did not have a living will. I guess, geez, doctor, I feel bad. I mean, the right decisions for someone who's 92 years old, that's not going to open up their eyes again, but you hate to be the one to say, okay, turn off the switch now. So, the power of attorney, once it's signed, it's a good idea to scan it, send it to the agents, the family members, and also to the banks or financial advisor. The living will should be signed and scanned and then sent to your doctors. Probate in New Jersey is easy. That's why I typically say there's no, I ask people, there's no reason typically to spend a lot of money on having, sophisticated trust done, because nowadays for probate, and to make it easier for people, I will fax or email a copy of the will, a copy of the death certificate, and the surrogate information sheet to the surrogate's office. And then my client will go down there you don't have to have an appointment, but appointment day is better. This way, you're not there for more than 15 minutes. You bring your checkbook, you $160 or so, and then they give you the paperwork, and it goes, the client goes, that was easy. He goes, yeah, that's because I know the system and I've done this ahead of time. So I thank the big crowd today and the people watching online in the Piscataway. And next, Dan, let's turn that off, and I'm going to have you come up and talk for a little while.